introduced by our MC just now, my name is Hani Afiqah. I'm one of the legal officers from MyIPO, Intellectual Property Corporation of Malaysia. So I'm not an accredited mediator, nor that I've involved in mediation process before this, and not going through any training to become a mediator. But I'm here today to represent MyIPO to share with all of you the IP mediation program and also initiative that we have implemented in Malaysia. Okay, as I glance through the list of participants, I noticed that the participants here are not only from the IP office, but also from the private practitioners. So my presentation will start with what is MyIPO, what is my organization. I think it is useful to understand where I came from. And then following that, we'll see on the IP laws in Malaysia. We have to understand whether in Malaysia, do the IP office provide a mediation process? Okay. And then later on, we'll see the legal development on IP mediation in Malaysia. And lastly, you have a conclusion of the overall of my presentation. Okay? All right. MyIPO. So MyIPO is just like IP office in Philippines. We are the only authority in Malaysia that provide a registration for IP. Okay? So before we are corporatized in 2003, before that, we are an agency, not an agency, but a department in Ministry of Domestic Trade, but only corporatized in 2003, and we are governed under the Intellectual Property Corporation Act 2002. So under the Act, the Act give the authority for us to manage the intellectual property system in Malaysia and also administer and enforces 6 intellectual property acts. So in Malaysia, I noticed that in EU IPO, you do not govern patents, but in MyIPO, we have 6 acts we govern. The first one is Trademarks Act 2019. Before 2019, we do have the Trademarks Act 1976. Then we revamped the act, we repealed the act, and we introduced a new act in 2019. And then we do have Patents Act 1983, and then Industrial Design Act, Geographical Indication Act, Layout Design of Integrated Circuit Act, and lastly, Copyright Act 1987, and also the subsidiary legislation. Okay? So that is all about us. So we move on to the IP laws in Malaysia. As I mentioned just now, we need to look into the provision in the IP law to understand whether in Malaysia, before our IP office, do we provide a mediation process. Okay, so as I mentioned just now, EU IPO do not have patents, but I think for completeness, I will look into the Patents Act as well. Okay, so under the Patents Act, we do have, we call it section as other countries as well, section 19, talks about judicial assignment of patent application. So this is about a granted patent and also a patent application. If you think that the owner, the applicant is not the rightful owner or applicant, so you can initiate a procedure in court, okay, before the court under section 19. And also under section 33C, court may order rectification of the register, meaning that if patent has been granted, so any person, okay, if you want to attack on the validity of the granted patent, you can go through under section 33C and you initiate the procedure in court, not before the IP office. So both under section 19 and 33C, if you have problems, issues with a granted patent or patent, you go through before the court instead of the IP office. Okay? Then we do have section 56, like other countries, to invalidate a granted patent. You want to attack on the validity as well, patentability and ownership of patent. And then we do have section 59, if someone else infringe your patents right, you can take an action and initiate the infringement action before the court only and not before the IP office. Okay, that is, and then we do have this one. We recently introduced in the amendments in 2022, service of application order or judgment on the register. If you look into section 88C, we only you see under subsection 4 there. So upon receipt of the order or judgment of the court, we will record the order and give effect to the order of the court. There's nothing in here stated on mediation or mediation agreement or something within that line. Okay? Okay, now we look into the Trademarks Act 2019, the new act. Okay, under section 35, opposition proceeding. So this is an inter-party proceeding before the IP office. Okay, but here in this section, you do not see that we give the opportunity to the parties to go through mediation first. Okay, we straight away go through the opposition proceeding. All right, and then we do have section 46. This is new one, revocation of registration by court as to non-use of trademark. This is different from 47. 46 is to revoke on non-use. Okay, also going through the court procedure. And then 47, invalidation to invalidate a trademark registration. And 56, an action for infringement. Also, you have to go through the litigation process before the court. right? Similar with Patents Act, they have Section 140 also under the Trademarks Act. They will give effect only to the court judgment and orders. All right. All right. Then I will touch on a little bit on Industrial Design Act. So the first one is Section 24, rectification of registrar. So once ID is registered, so any person, okay, if they wanted to invalidate the patent or rectify the patent, they can go through the proceeding in court as well. Right? Revocation, you can go to the court, and cancellation. A is on the revocation or novelty issue, and B on cancellation if you got the registration by unlawful means. Okay? And Section 33 on infringement proceeding. So overall, from the 3 acts, patents, trademarks, and ID, you see that there's no provision that allow for mediation to go through before the IP office. Okay, we do have inter-party proceeding under the Trademarks Act, opposition, but as well, but in that proceeding as well, we'll go through like a litigation process instead of a mediation process. Okay, overall in Malaysia at the moment, currently, we do not have mediation process before the IP office, not like the EU IPO. Okay. All right. Next, the legal development in Malaysia. So I'm from the IP office. I'm not from the other institution, but I'll cover the legal development on mediation from other institutions in Malaysia. Okay, the first one in Malaysia, we do have Mediation Act 2012. Sorry, there's mistake up there. So the Mediation Act 2012 is enforced since 1st August 2012 throughout Malaysia. Because Malaysia, we do have West Malaysia and East Malaysia. Okay, East Malaysia, the Borneo, Sabah, and Sarawak. But this Mediation Act covers both component, West and also East of Malaysia. And then the Mediation Act, when we introduced in 2012, is to promote, of course, to encourage people to use mediation as an alternative option for you to resolve any dispute. All right, and also to facilitate the parties if speed is of the essence for you. All right, and cost also, for cost efficient process, you can go through mediation under the Mediation Act 2011. All right, so if you see here under the Act, it provides that the procedures or the dispute which mediation is not allowed. Okay, if you see from the list here, there's nothing mentioned here that IP is not allowed for mediation. So in other words, so if you want to mediate on IP dispute, you can, okay, through the IP Mediation Act, but not through the IP Acts that govern by MyIPO. All right, go on here. So this is a bit the salient features that I take out from the Mediation Act. Okay, Mediation is not governed by us, but these are all the salient features that I would like to share with all of you here. So the first one is steps to commence mediation. I think it's similar like EU IPO. Okay, a person, it can be unilateral or jointly by both parties. Okay, you can apply, initiate by sending an invitation. If this is a unilateral process, you can invite the other parties to go through a mediation process. Okay, if it is accepted, okay, then both parties will enter into a mediation agreement to appoint a mediator, okay, and also to discuss on how the process will take, sign the agreement, and the mediation process will be initiated. All right, and then the mediator will be the qualified with knowledge and experienced mediator, as mentioned by representative from EU IPO. The mediator must be independent, all right, must be independent, must be neutral, must be impartial, okay. And there's one interesting provision in the Mediation Act that states that mediator will not be liable unless in a fraudulent or willful misconduct, because the mediator, as mentioned by EU IPO just now, they will just act as to facilitate the procedure and not provide any resolution, okay. All right, then on confidentiality, as others ADR procedures, confidential is very important in mediation. They will conduct privately and prohibit the disclosure of the oral or written statement, even though in the mediation process the parties could not have an amicable resolution. So whatever discussion that have done during the mediation will be confidential and will not be an evidence in the litigation process later on. Okay, if they decide to go for litigation in court. All right, and lastly, if both parties agrees to have a settlement agreement, they will settlement resolution. They will sign a binding settlement agreement. And then, if at the point of time a court proceeding has been initiated by the parties, they can enter the mediation agreement as a consent judgment of both parties. All right. All right. The second initiative in Malaysia, The first one is Mediation Act 2011. The second one is Court Annexed Mediation, which is mediation conducted by the representative of the courts. Okay, it is governed under the Rules of Court 2011. If you see under the subsection 1A here, if a judge of the High Court identifies that an issue arising in the action or proceedings between the parties can be resolved by way of mediation, okay, the judge may refer the parties to the mediation as prescribed by practice direction issued from time to time. So, under the Rules of Court, it is expressly stated that if you have initiated a proceeding in court, okay, when the judge go through the course papers and they notice that they're aware that, okay, this issue can be resolved between parties by going through a mediation process, the court will ask the parties, okay, to consider it first. If they wanted to, they can file a form. There's a prescribed form provided by the courts to file with the registrar of the courts. All right? Okay. Can you see the picture here? Okay. So basically, I took this from the court's website. All right. So basically, why do we need mediation? I think this is the same as explained just now by our representative from MyIPO. The first one is mediation is an alternative resolution, okay, to resolve a dispute instead of going through a hectic full trial before the court. Okay, if speed is of the essence, of course, you will go through mediation instead of the litigation process. Okay, and then same like MyIPO, the mediation process is free of charge. Okay, it's free before the court, is free of charge. And then the mediator consists of experienced and knowledgeable judges. Okay, so let's say you file you file an action through the court, and I'm the judge presided for the case, but I'm not going to be the mediator if you choose to go through a mediation process. Okay, I will still sit as the court judge for your initial action. All right. Thirdly, okay, no party loses because the agreement to settle is a win-win situation. Number 4, the settlement agreement is binding, okay, according to the contract law. So you can enter the agreement as a consent judgment between two parties, and then can save time, of course. Right. Number 6, mediation is private and confidential because you have signed the NDA between the parties. Number 7, mediation can strengthen the relationship. If you want to protect your business interests, your reputation, of course, you will opt for the mediation instead of the litigation process. All right. Number 8, the mediation process is informal and flexible. Of course, you can, if you are comfortable. I'm from Malaysia. Okay, our national language is Malay language. If you are comfortable with Malay instead of English, okay, you can opt for Malay instead of English. All right, because in court, in the High Court for IP, we mostly use English instead of our national language. All right. And then lastly, facilities. Okay, facilities at the mediation center. We do have mediation center in KL, in Kuala Lumpur High Court, in our city center. Okay, we do have facilities for mediation instead of you feeling anxiety to appear before the open court for litigation process. Right. Okay, this is basically the flow chart for the mediation process. Can you see the diagram? Is it too small? Do I need to zoom in a bit? I hope it's not too small. All right. All right, so basically the court will ask the parties to consider whether they want to go through the mediation process, and then they will fill up, there's a prescribed form as I mentioned earlier, Form C, okay, and Form 1, and then the court will register the case for mediation and schedule for the parties to meet up with the mediator. All right, then mediation will start either through physical process or online. We do provide an online mediation process. And then if mediation is completed, successful, we will record the consent judgment, okay, and then file a notice to discontinue the proceeding in court. All right, but if unsuccessful, the parties will go back to the judge and ask for further direction from the court, all right, to proceed with the trial. So this is the example, the template of the form if the parties intended to go through a mediation, court annexed mediation process. All right, so in the form it's stated here, it is both parties have to sign this form. Okay, the mediation process conducted is closed process, attended only by the parties and also the counsel of the parties. So any disclosure, admission, and communication made during the mediation are confidential and without prejudice. Number 3, all communication during the mediation shall not be part of the record of the court procedures. Okay, because it is confidential in nature, cannot be open in the open court, right? It cannot be disclosed in the open court. Lastly, neither party shall call the mediator to give evidence, okay, because the mediator is just to mediate the proceeding. in relation to the mediation process conducted by the mediator for the proceeding. Alright, this is our third initiative in Malaysia. Alright, the third one is under ASEAN International Arbitration Centre, which we call it as AIAC in Malaysia. Okay, the AIAC, previously known as Kuala Lumpur Regional Arbitration Centre, it was established on 17 April 1978 but renamed as AIAC on 28 February 2018. So it is governed, the act governed AIAC is Mediation Act, as I mentioned earlier, the Mediation Act 2011, and then they do have their own rules. Okay, previously they have AIAC Mediation Rules 2013 and 2018, but recently they amended both rules and they now have the AIAC Mediation Rules 2023, which take effect from 24th August 2023. Okay, both two rules have been repealed by the new one. Okay, so basically there are 6 salient features of the AIAC. Right, covers not only a domestic mediation. So because our topic here is only on mediation, we limit to mediation, not ADR as a whole. So the salient features here is related to the mediation process under the AIAC. Okay, so it covers domestic and international mediation. So let's say if the other parties have a place of business not in Malaysia, outside of Malaysia, okay, they still can go through a mediation or ADR process under AIAC. We call it international mediation. Alright, secondly, the cost involved, of course there's cost, not like court annexed mediation just now, which is FOC. So under the AIAC, there is designated or prescribed fees and also administrative charges imposed by the AIAC for using their facilities like the mediation room. All right. And then commencement, if you want to initiate a mediation process under the AIAC, you have to submit a request. Okay, submit a written request to the director of the AIAC. And then the parties may replace the mediator at any time because the process is flexible. All right, the mediator can communicate with parties together or separately. Okay, not like court. Both parties have to appear before the court, but in mediation, you can have a session privately with the mediator, one-to-one session. And lastly, if the parties agree to settle their dispute, so they will sign a settlement agreement. It can be used as evidence for seeking relief later on at the court. Okay. 11:15. I'm almost done with my presentation. All right. The fourth initiative in Malaysia is under Malaysian International Mediation Centre. This is different from the AIAC. Okay. The Malaysian International Mediation Centre is established by the Bar Council of Malaysia. The Bar Council, I think, similar like in Philippines. The Bar Council consists of all the advocates and solicitor. Okay, the licensed advocate and solicitor. They established the Malaysian International Mediation Centre. It has been renamed on 15 January this year. Okay, it has its own mediation rule. It's governed under the Mediation Act 2011, but they are governed by their own rules and code of conduct. They do not follow the AIAC rules. Okay, they have their own. They also, some of the services provided by the MIMC is they provide workshop to the accredited mediator. Okay, and then the mediation process also subject to fees, is not FOC. Right? Okay, the fifth initiative, we do have other mediation institutions in Malaysia, not only AIAC or MIMC. We do have Securities Industry Dispute Resolution Centre. We do have Mediation Centre for Sabah and Sarawak, because as I mentioned just now, in Malaysia we do have West and East Malaysia. Okay, if it's troubles, it will trouble people to come to KL just to mediate their action, so they can just go through a mediation centre in Sabah or Sarawak. Okay. So overall, in a nutshell, all right, as I mentioned just now, there's no express legal provision under the IPX in relation to the mediation, but we do have a Mediation Act, a sui generis Mediation Act 2012, and we have a lot of institutions that conduct a mediation process in Malaysia. Okay, so we may, in future, that is my role for today, to be involved in this conference, to look into a mediation process established by MyIPO and bring back that initiative in Malaysia. We'll present it to management. Maybe in future we'll introduce our own mediation process before our IP office. That is all from me. Thank you very much.